Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. Our guest today is Ed Herman, one of the 4 partners at Brown and Crouppen, a large personal injury firm. The firm represents individuals who have suffered injuries either as a result of someone else's negligence or while on the job, including medical malpractice, defective products, bad drugs, and accidents. Mr. Herman is a plaintiff trial lawyer. He represents individuals who have been injured. His job in legal phraseology is to make his clients whole. In other words, get them back to where they were before the negligence or injury occurred. Today we're going to talk to him about the civil legal system. We're going to also talk about legal concepts like excessive lawsuits, frivolous litigations, and tort reform. Ed Herman, welcome to Conversation.
Thanks for having me.
So let's start from the beginning. You're with a company called Brown and Crouppen. And
Yes.
For those of us in the St. Louis area, we've seen your commercials for a while.
Right, we started advertising.
Only you're not in that commercial.
I will appear in some of them. There's a famous one of the 3 of us walking down the hallway together and walking into the courtroom, and that was Terry
that was
Crouppen,
you.
Andy, and myself.
Okay.
Yes, I'm
I've
what
met
they call lawyer number 3 in that
Yes.
commercial. I'm the one that says cell phones off. That's sort of a famous bit. But no, Terry Crouppen has been the spokesperson for the firm for the last 30 plus years, and his son Andy Crouppen, who's another one of my partners, has also sort of taken up the mantle and has acted as spokesperson as well for the next generation.
Mm-hmm. And how long have you been an attorney?
I graduated Washington University School of Law back in 1997, and I've been with Brown and Crouppen since 2001. But prior to joining them, I spent some time on the plaintiff side, and then I also spent a few years on the defense side, sort of learning how the other side operates.
Mm-hmm. And now some people who are listening to this may not have a clue about plaintiff versus defense sides. I don't believe that they're aware that actually lawyers tend to specialize in one or the other. So why don't you define, I called you a plaintiff lawyer in the opening, and you just used the term defense. So why don't you define what those two are like?
Okay, well, first of all, to really understand it, you have to quickly just know the difference between a criminal case and a civil case. You know, criminal case is brought by the state, and it's to prosecute a potential criminal. And we all kind of have seen that on television. The civil side is when it's a person versus either a person or versus a company, and it's when they feel like they've been wronged somehow, usually something of either an injury or an economic damage. And so the plaintiff is the person bringing the claim. They're the one who feels that they've been wronged, something's been taken away from them, or they've been injured, damaged, and now they're going after the person that they feel is responsible for it to get that back.
They're the ones that got hit in a car accident.
Yeah, or you know, they were the victim of it, or it could be a victim of, like you had mentioned earlier, using a defective drug or a defective piece of equipment, or maybe they're injured on the job. You know, think of it like this: they're the injured person who is not at fault.
Okay, and then there are attorneys on the other side.
There are. Typically what will happen is plaintiff's attorneys like myself, we will work on these cases. Generally, we work on a contingent basis, meaning that we don't bill by the hour. People hire firms like ours that are just ordinary citizens. They don't have the kind of extra money to just start, you know, racking up big legal fees. So the system is set up to where we kind of put our money where our mouth is. You know, we bring the claim. If we're successful, we get a percentage of the recovery. If we're not successful, we don't get anything for our efforts. The defense side, typically when you're bringing a claim, there's usually an insurance company involved in the claim. They'll hire an attorney if they don't have some in-house, and they'll hire firms that are generally defense firms, and they do bill by the hour if they're not in-house, and they work the other side.
Typically, what's the cost of a defense attorney per hour?
You know, it depends. It's very competitive. You know, because litigation, and I know we're going to talk about it later, but because litigation has gone down so much over the last 2 decades, fewer and fewer cases are being brought, and fewer and fewer cases are going that far into litigation. So defense firms have gotten very competitive. If you're on a high-end case, a product liability case where you have to be a real expert, Those defense lawyers can charge anywhere from, if you're a partner and seasoned, it could be $500 an hour, it could be $700 an hour. In the bigger cities, it could be $1,000 an hour. If you're an associate on the defense side, you might be billed out at $200 to $400 an hour, somewhere in there.
Mm-hmm. What if you are just like a little subdivision, or you're a trustee in a subdivision, and all of a sudden somebody, whatever, just feels wronged, and it happened in that subdivision, and now subdivisions can't afford $200 an hour even, or $300, you're talking $500 an hour. What are they supposed to do?
Well, usually they should have insurance for whatever the claim is being brought against them. And typically when you carry insurance, included in your insurance is a cost of defense. Usually the insurance company, as part of the policy that you have, will defend that case, and they'll actually pay for the attorney. Mm-hmm. And the good news is, I guess, is that if you're a subdivision, if it's a really small entity that doesn't have insurance, usually the plaintiff side winds up not pursuing the claim because
there's no pocket.
There's no money at all.
Right.
It's a sad reality, but it doesn't really serve anybody's best interest to pursue a claim that's never going to make the plaintiff whole. And you have to be honest with your plaintiff and say, listen, we've done a check here. There's no insurance policy that's going to pay on this. There don't seem to be any easily acquired available assets. So, your justice is going to be in name only. It's not going to actually make you whole. So you have to be honest with the plaintiff at the beginning so you don't take them down a path that's going to take them years of their energies to something that's not going to take them where they want to take them. And usually in those circumstances, a plaintiff is forced to abandon their efforts to become whole.
In my introduction, I used the word make whole.
Yes.
That is an accurate description of what you're trying to do.
I think it's exactly accurate, yes.
But in reality, though, when you say make whole, I mean, if somebody's been seriously injured on the job or in a car accident or have taken a drug that has done them serious injury, whole in this case is actually economic balance, isn't it? Not putting them back to health.
Right, of course, yeah. I mean, believe me, in a perfect world, that's what you would want to do. I mean, you'd want to take the injury away completely. You'd want to remove the pain completely. You'd want to raise the dead if it was possible. But no, we're talking about economically whole. We're talking about a person who lives paycheck to paycheck, as most people do, who really can't afford to be in the accident, not just because of their physical health, because they can't lose the time from work. They start losing time from work, they're not getting paid. That puts their job in jeopardy. All of a sudden they have medical bills that rack up very, very quickly. And even if they have health insurance, there's all sorts of deductibles and other portions of that they don't have the money for. So when we talk about making them economically whole, we're talking about getting them enough of a recovery to put them back financially where they would have been if the accident hadn't happened. So that may include their lost wages, it may include their unpaid medical bills.
From an insurance point of view, when people are thinking about their insurance policy, describe to them the value of MedPay in their insurance.
MedPay, if you don't have it on your auto insurance, it's an absolute must. The beauty of MedPay is, think of it like it's a miniature health insurance policy that you get attached to your auto insurance. And you can buy it, they have increments of $1,000, $2,000, $5,000, $10,000, even $25,000. It costs very little. It adds very little to your premium. But if you're in an accident, it will provide that much money to go towards your medical bills, whether you're at fault for the accident or not. And it will travel with you from car to car, and it will cover anybody that's in your vehicle. So let's say you're driving the carpool, and you caused the accident, and you've got your son in the back seat and two of his friends, and everybody has some injuries. It's nice to know that you don't even have to tap into your liability policy where you might get sued, that you have MedPay there, cover your bills up to whatever amount you got, cover each of their bills, because those limits are per victim. And that's nice about MedPay is that it'll go towards your deductibles, it'll go towards your prescription medications, and it will pay for the type of medical coverage that your health insurance might not even cover, potentially plastic surgery, potentially dental work. So all sorts of things that may come up in an accident. If you don't have MedPay, and I don't work for the insurance industry, I'm plugging their product, but it's a good product. I carry it. I carry 25 grand of MedPay on all of my cars, just because it's a warm blanket of security.
Yeah, I'd heard about MedPay being an important issue, which is why I wanted to bring it up so that people could.
Did you ever anticipate such a complete answer to that question?
From someone like you, I did. Yes.
I'm just playing.
But so let's see. We were talking before about defense attorneys versus the plaintiff's attorneys. The defense attorneys work for the insurance companies then, right? When you're in court, you're really not up against the company, right? You're actually up against the company's insurance company.
That's true, but usually jurors don't always understand that, and it's not admissible at court. I can't go up in a car accident case and say, well, don't worry, this defendant has Allstate insurance. They're actually going to be the ones paying on this. When it's presented to a jury, they just see it as the plaintiff against this defendant. And that also plays a big part because not all defendants aren't all bad people. They're just like you and me. Anybody can cause an accident. And they may be the nicest people in the world, and they may go to trial and say, listen, I feel terrible that this happened. I want this person to be taken care of. I just want to, I don't want them to be paid more than what I think they should get. And a jury can hear that and be very sympathetic toward a defendant, and it happens quite often. So they don't know necessarily. You hope that they know. As a plaintiff's lawyer, you hope that a jury is like, understand we probably wouldn't be here if there wasn't an insurance company that's going to pay on this, but it's not actually admissible in trial.
Do you find that certain courts are a little, and I don't mean I'm talking about the juries that appear at these courts, tend to go one way or the other, that they're more towards the defense, they're more towards the plaintiffs?
Well, my personal belief is that if you have a good case and it's well presented, and maybe this is my own arrogance, and it may very well be, that I could take 12 of my enemy, put them on the jury, and if they're willing to be fair and impartial, they're going to come out in my favor. That being said, the more a jury can relate to a plaintiff, the more likely it is they're going to see things from that plaintiff's point of view. So depending on who your plaintiff is will dictate which court is going to be more favorable to them. The city of St. Louis, or the eastern part of the southeastern part of Illinois, if you're in a court that is going to be a little bit more diverse, economically diverse, more so than racially diverse. I think economically diverse is more the key. People that have less money will relate more to a plaintiff who's struggling. It will mean more to them when they hear this person's living paycheck to paycheck and they missed 2 paychecks and it derailed their life. I think people that make less money can relate to that. I think people on juries that make more money, they just have lost touch with that. It doesn't seem like as big of a deal. So in an ideal situation, I think you're always going to do better in courts where the jury pool is made up of people who match the plaintiff.
Some of your clients who are injured, for whatever reason, are their lives really devastated by this and changed?
In ways that you wouldn't even imagine, and it's not just the most severe cases. I think anybody can look at a case where a family member's been lost or paralyzed and say, well, of course that's changed their life. But again, most people who are just sort of getting by, it doesn't take that much to put someone's life in sort of a tailspin. A simple,
kind of like losing a car, so no, you can't get to work
exactly,
anymore.
and that's exactly what happens. So let's say you're rear-ended, and let's say you're a person that lives paycheck to paycheck. You're rear-ended. Your car's not drivable. You may not be able to afford to run out and get a rental car right away. So you think, well, the people who are responsible for it, they'll get you in a rental car, will they? Not right away. They don't want to. They want to, you have the burden of proof, even in convincing them early on. They'll say, well, we haven't spoken to our insured yet. We haven't taken their statement. We haven't accepted liability. We haven't seen the police report. The police report may not be ready for 2 weeks. 2 weeks? 2 weeks without a car for someone that's got 2 kids, needs to get groceries, it could be a single parent, needs to get to their job, has a boss that doesn't understand. You miss a couple of paychecks, all of a sudden the rent or the mortgage isn't being paid. There's no way to feed, and very quickly it derails. And then the insurance company will have the nerve to say, well, if your person was hurt so bad, why didn't they get to their doctor's appointments that first week? I said, well, they didn't have cab fare. They didn't have any way to get back and forth. They lived in pain, as people do, all the time. The lucky ones are able to get the medical treatment that they need and are able to sort of get better physically. But in those crunch time moments, you know how it is. People usually suck it up, stuff a lot of Advil in their mouth if they have it, and try to do the best they can to find a way just to keep their job. So, but yeah, we see it all day long, and it keeps us motivated on a daily basis. Even on cases that to the outside world look like small cases, I don't think we handle any small cases in the office. I think to that person, it's the biggest thing that they're dealing with right then.
Okay. Now, you're licensed in Illinois.
Yes, I am.
Right? So you're aware of the courthouse in Edwardsville, Madison County.
Sure.
Okay.
The reputation that goes with it.
Right.
Sure.
Now, Madison County Court, which is part of the 3rd Judicial Circuit in Illinois, has traditionally been the place that river cases come to. And this is part of what I wanted to ask you. How is it that somebody that could be injured down in I guess it's Biloxi or anywhere down towards New Orleans on the Mississippi River or up towards Minneapolis on the Mississippi River, boom, they're an entirely different state when they're hurt, and yet they want to come to the courthouse in Edwardsville. Why would that be, and is that right?
Well, I think that first off, the idea of trying to get in the best forum possible is the obligation of a plaintiff's lawyer. You're trying to always bring your case in a place where you feel like...
What's the legal term for that?
Forum shopping. Some people will call it forum shopping, but really, to me, it's just due diligence. When the time comes to even file a case, and understand that very few cases get filed. Quite often, efforts are made long before then to resolve the claim without ever getting into litigation, and most claims do.
This is called settlement?
Yeah, we settle a case prior to litigation, and it comes up so often. I wish the public was more aware of it, because I think what happens is, part of why I think plaintiffs' attorneys will sometimes get a bad reputation is because they'll see cases that wind up at trial, and some of them may look a little bit iffy to them, but understand that that's why it's gotten that far. If it was a surefire winner every single time, you may not have gotten as far as you've gotten. So many of those cases will have settled already. But when the time comes to file the suit, plaintiff's attorney has to evaluate all of the places that they may be entitled to bring the claim. And in those situations, a lot of where the business takes place sometimes is an opportunity to file a claim. Where the defendants have their central place of business, or where they do a substantial amount of business, you open yourself up to various jurisdictions when you do business in a lot of places. And when you're along the waterways, there are ports, there are places that you stop along the way, and there are usually ways, not always, but there are usually ways to tie the litigation to anywhere along the route that business occurred. And it really depends where the where the accident happens is not necessarily the same place where the act of negligence occurs. You may be claiming that an inspection was supposed to have taken place that didn't take place. That may have happened here in Illinois. The accident may have then happened subsequently further down south. But you can tie, some of the action, some of the activity here. But let's be honest, the reason you do it is because Madison County traditionally was a more favorable venue for plaintiffs. And that wasn't really because of the jurors. That's usually because of just the general climate, the judges that are there. And usually, understand that a judge can have a lot of influence over a case, but they still are all bound by certain guidelines, but there's a lot of give in those guidelines. And, I'm a plaintiff's lawyer, so I'm going to feel this way, but I feel like the judges who err on the side of letting the plaintiff share their facts, letting them tell their story, letting them put them all out there, I think those judges are in the right. I think they err on the side of allowing more information and let the jury decide. A lot of people gloss over the fact that we have a 7th Amendment right to a civil trial. That's the 7th Amendment of the Constitution. And, you get people who are big advocates of the 2nd Amendment, and God bless them, and they'll fight for any limitation at all that infringes on that. And yet our 7th Amendment right to a trial by jury is constantly infringed upon, and nobody even seems to understand that their rights are being taken away from them.
Which brings us to the term tort reform.
Yes.
Okay, now describe what is going on there from your perspective.
Tort reform is a fancy way of saying the insurance companies and the pharmaceutical companies, which are the two richest lobbies in the country, and the medical industry, they get together and they try to say, maybe we can limit our liability on the front end before a claim even gets to be made. Maybe.
First, pause. What is a tort?
A tort is
Besides
it's just a civil wrong.
civil wrong.
It's just the fancy word for a civil
So
wrong.
on the civil side, it's the same thing as a criminal act would be on the criminal
Right.
side.
It's just a civil wrong, and you've heard all of them. It could be negligence, it could be malpractice, it can be defamation, it could be libel. Any civil wrong, any wrong where the remedy is money is a tort.
And how do you limit on the front end then?
Well, the way you limit on the front end is you basically draft the laws in a way that just prevents you from ever getting to the courthouse. You know,
How so? Give me an example.
The classic example, the easiest for the public to understand, is when they just put caps in, where they say no matter what the actual value of your claim is, we're not going to allow you to collect more than $250,000 on your claim. We're just going to put a cap in. And to me, the cap is the most egregious violation of the Seventh Amendment, because the Seventh Amendment very clearly says that a jury gets to decide, you know, how the case is resolved. And when you basically put a cap on a claim, you basically have said, no, the jury is not going to decide this. Even though the Seventh Amendment couldn't be clearer, the jury doesn't decide it, because if the jury wants to give something above that, we've now written a law and passed it that says it's going to be capped at this amount, and the jury's not even going to know about the cap. They think they're doing right by the person. And then all of a sudden, the judge is going to say, well, it's capped at this amount. Well, you know, think about a cap. Now, some states cap all damages, whether they're economic or non-economic, which to me is insane, because that hurts everybody. You know, the doctors may have given a person $1 million worth of medical treatment, and because the cap may only be $500,000, now it's not just that the person's not getting the money, it's the doctors aren't getting the money either. They don't understand that. A lot of states will cap your non-economic damages. Those are the ones that people will say are, you know, for your pain and suffering, for your loss of enjoyment of life, and loss of activity, loss of companionship, those sort of things. And granted, those things are hard to put a number on, but it's inherently unfair that if a person's actual losses are $250,000 or $350,000, they get 100% recovery for their loss. But a person's losses are $3.5 million, and they're capped at $350,000, they only got 10% of what their claim was worth. 10% justice. And that's, you know, I mean, anybody could look at that and say, well, that's not appropriate. But that's tort reform.
Switch sides. Argue why your colleagues on the defense side believe that this is the right thing to do.
They want to pay less. I mean, it's as simple as saying, if you control the game, if you ask the public, hey, how would you feel about a cap on gas prices? That no matter what happened with the market and the economy, you'd never have to pay more than $2 for a gallon of gas. You know, that sounds pretty good. And if they can make that happen, who wouldn't want to pay less? But the insurance companies and pharmaceutical industries, they have so much money, they control the game. They can actually get people elected, and then those people can actually vote in their favor. And it's as simple as that. The sad part is, Lee, that they've convinced smart people that this is in their best interest. They've convinced the medical profession, hey, you know, give money to these candidates because they're going to be in favor of caps on malpractice claims, and your insurance premiums are going to go down. But they never go down. Claims went down. When they put in the malpractice caps, malpractice claims went down because lawyers can't afford to spend hundreds of thousands of dollars working up a case if they know that the absolute most that can be won is $350. The economics don't work. They can't take that case. So claims have gone down, payoffs have gone down. The only thing that hasn't gone down are malpractice insurance premiums, which still continue to go up.
We got about 5 minutes left.
Okay.
Whole industries, though, have been affected by insurance liability. For example, the asbestos industry.
Yes.
How do we balance that, or is there a balance from your perspective?
Well, here's how I see it. I think everybody has an instinct, even children have an instinct for what's fair. You know, they have an instinct for accountability. Now, a child's instinct when they take a cookie out of the cookie jar and you question them about it, they say, no, it wasn't me. They do have an instinct to defend themselves, but when they look at a situation, and we tell people all the time, where's the accountability? Nobody's held accountable for anything. Well, the whole point of the plaintiff's profession is to actually hold people and industries accountable for the wrong things that they do. Asbestos is something that those companies knew 30 years ago was deadly. And the bigwigs who were making all the money, they just didn't care. They didn't care about the workers. They let it happen because the money was there for them. And they said, who cares about claims that aren't going to come up? They knew the science. They knew that these claims weren't going to come up for 20 or 30 years. They put it off like so many people put it off. Eventually, you reap what you sow. What goes around comes around. These are valid claims. These are people who never should have been put in this situation, and they're going to die. Mesothelioma is a 100% deadly disease, and it's only caused by one thing, and it's asbestos exposure. So is it ever too late for justice? I mean, is that what we want to tell people? That, come on, it's been 20, 30 years, just let it go? Why should these people let it go? Why should anybody let that go when they've been harmed like that? Mm-hmm. So I'm not telling people be out there to be vengeful, but I do think that people have a sense of justice. And I think that we can't just go around talking about accountability and then make the bad guys out of the one profession that says, you know what, we're going to hold these people accountable, and you know what, you don't even have to pay us unless we're successful. What other job does that? Does a doctor tell you you don't have to pay him unless he cures your illness? I mean, nobody else does that but us, but we do it because that's the only way that you can really level the playing field and let just a normal guy, normal family, how else do they take on a giant? Somebody has to step up and be that person.
Is there any suggestions that you might have to, because you mentioned the political aspect of all this, is there something that the public can do to defend itself?
Well, I think that a couple things that the public needs to know is, for one, they have to educate themselves a little bit more about how these issues are going to affect them personally. Perfect example. A lot of hospitals are starting to get their patients to sign mandatory arbitration clauses, where they go for just a medical treatment and they're given a bunch of paperwork and they're filling out HIPAA and they're filling out this, and then they get this thing called the mandatory arbitration clause. They say, well, what's this?
Do they have to sign that?
Well, some places will make you sign it, or they won't treat you. Mm-hmm. Other places it's voluntary, but people, they're being asked by the doctor's office to sign something. They don't want to take a political stance, and then they're going to worry, am I going to get the same level of treatment that I would have gotten, or are they going to look differently on me because I wouldn't sign their paperwork?
So arbitration says they can't come to you.
No, they can come to a lawyer, but arbitration says they cannot ever file the case in a courthouse. Basically, what they're asking people to do is, would you mind waiving your 7th Amendment right in the Constitution? If they asked you to waive your 1st Amendment right in order to be treated at the doctor, would you do it? Of course not. Mm-hmm. But to just say, if we're going to even look at you, you got to promise us ahead of time, before we've even made a mistake, you're never going to sue us. You have no right to sue us. And major hospitals, these aren't small hospitals. This Washington University and Barnes Hospital asked their patients to sign this. I went to have a gastric surgery back in 2011, and the first doctor that I was going to go to would not operate if I didn't sign one of these, so I didn't sign it. I went to a different doctor. But these are the things the public doesn't really know about it. I do everything I can to get the word out, but these are things they absolutely should not sign.
Well, we've about run the course here. It's gone by so fast. I'm going to have you back again so we can carry on this conversation.
I appreciate it.
Again.
I really do.
It's I've learned a lot. It's been a lot of fun. I really do appreciate your coming. And we're not paying you any $500 an hour.
No, of course not. I'll come anytime for free.
And it's been great. Thank you very much for being with us.
Thank you for having me.
You're very welcome. And to my audience, I've been speaking with Ed Herman. He's a partner with Brown and Crouppen law firm. We had a very interesting discussion here about your legal rights. We also, at the end, talked a little bit about the political nature of the legal system. This is something that you might want to spend some time thinking about and talking to the people who you are voting for to find out where they stand. Thank you. Oh yes, this show's available on YouTube. Show it to your friends. Goodbye.